Thank you, Tina. Joining us next on the show is our real estate lawyer from Rathor Baig, and he's broker-owner from Remax Empire Realty, Ricky Rathor. Ricky, welcome back.
Happy to be here. Thanks, guys, for having me.
Ricky, we got a question for you from one of our callers, and what they've found is they moved into this new property. 2 days later, basement floods. There's water everywhere. There was no mention of this during the agreement of purchase and sale signing and discussions and negotiations. And upon the seller being called and contacted, they deny any knowledge of this. What can you tell us from a legal perspective? What happens next?
Love it. So, Asif, in a situation like this, ultimately, you have to appreciate that when the deed is registered, the buyer becomes the owner. It is possible, quite frankly, that the issue arises after the transaction closes. And if such is the case, then that's just your bad luck. And as a buyer, that's something you'll have to face. Now, on the other hand, if it's something that the seller was aware of, they concealed it, and they misled you to believe otherwise that everything was okay, then you may have potential legal recourse.
Well, how do you prove that, Ricky?
What's that?
How do you prove it?
So, Tina, at the end of the day, I think, the overarching topic here, it goes back to the basic legal presumption and principles. So we have this whole idea of what we call caveat emptor. Whether you're buying a mango or an orange or a car or a house, the default legal presumption is, as a buyer, insofar as possible, make reasonable efforts to conduct your own investigation of the item or whatever it is you are buying. Seller does not need to hold your hand and point you to any sort of defects in a property unless such a defect is considered hidden or latent, and more importantly, renders the property unsafe for occupancy or uninhabitable. So as a seller, I'm not going to hold your hand and say, here's a broken window, this toilet doesn't flush properly, anything that you could have uncovered through a reasonable inspection. My position may be that that's your problem. You should have figured it out. I don't need to disclose that to you. Whereas on the other hand, if it is an issue that I am aware of that is latent and you wouldn't be able to uncover through a reasonable effort, then I may have obligations to disclose it to you. Now, with all of these things considered, the caveat being that this is the current state of the law. Just like I don't have to disclose death, murder, suicide, and the things that we discussed in the previous show, I don't need to disclose these things presently. We don't know where the legal precedents will go in the future. It's only a matter of time before something like this does end up in court and we end up with the answers we're looking for.
And Ricky, I noticed you mentioned mangoes and oranges in your description, but you left out lemon. Getting to another question that this person had. This is a condo townhome. What obligation does the condo corporation have to remedy this because the water is coming from outside?
So I think what I want to do is I want to answer this in two different aspects. So first off, going back to the original question, Asif and Tina, if you are a purchaser and you want on the record that the seller is not aware of any issues with the property, there's no death, no murder, no suicide, no water damage, penetration, anything like that, put it in your contract, your agreement of purchase and sale, and more particularly reserve representations and warranties that will not come to an end once the deed is transferred to the buyer. If those representations and warranties survive the closing, you may be able to hold the seller accountable if something were to go wrong. Now, to further this point, you also, as a buyer or as a seller or as a realtor involved in the transaction, have to play it based on who you represent. So if I represent a buyer, I'll put in a provision that the seller represents and warrants the chattels and fixtures will be in good working order. And then I'll want it to say that this warranty shall survive and not merge on completion, meaning even after closing, if I find out after a reasonable amount of time the appliances are no good, I could potentially come back with a claim. Whereas when I'm representing a seller and I receive an offer like that, I will strike out the last part where it says the warranty will survive and not merge, and I'll let the other salesperson know that we don't have any issues with the appliances. You conduct as many investigations you want before the closing, but a minute after closing, if you go in and put bath salts into the dishwasher and then come back and say it's not working, not my problem, not my client's problem. So you tailor your contract accordingly. Now to the second question, with a condo, it all comes down to which part is affected and whether that part constitutes your unit or if it's a common element that's affected. Now, what's very interesting is that condos have insurance, but that insurance usually doesn't cover your personal items. So if there is a flood that intrudes into the property and makes a muck of your carpet, your broadloom, your, whatever it is that becomes exposed to this element, those things would be claimed under your home insurance policy that you would have as an owner for content. Unfortunately, the condo would repair the issue, but they would not make you whole for anything that you have lost. You would have to have your insurance for something like that. So it really comes down to where do we draw the line in terms of ownership? What is yours and your responsibility, and what is the responsibility of the condo corporation?
And so basically the unit itself, if the leak is found to be affecting the unit itself and not from one of the common elements, what would a common element be in a condo? Would it be the exterior wall that connects all the townhomes together? Where is that line?
It all comes down to how the condo is created, how it's registered, and where they draw those boundaries. In the condo documents that we review, these are the sorts of things we look out for. Even such a thing as a drywall in a washroom. Well, on the inside of the washrooms, that space may be considered mine. Right behind the drywall may be considered a common element. So it really comes down to how it's registered and what's structured. I think the starting point in this situation is to understand what you own and don't own, and what you own in proportionate shares in the common element. And you look at the insurance policies and you go backwards. I had a situation in my law office where the abutting unit was a residential condo. I'm in a commercial condo. They had a massive flood last year when the pipes bursted, and that caused flooding into my particular unit. They made, the repairs for the pipes in their space, but all of the damage sustained in my unit was my responsibility.
And let's talk a little bit about insurance. So it is, you're adamant that purchasers will have insurance on the property prior to closing, right? And is that standard with all lawyers, or do you need that insurance to close?
So here's where we draw the line. If a client comes into my office and says, Ricky, I don't believe in interest, I don't believe in insurance, and sometimes I have clients who believe that whatever's going to happen in their life should happen because it's supposed to happen, and that you should not hedge against such risks. There are clients that will walk in and say, I only deal with cash, I don't borrow money, I don't believe insurance, I don't want the insurance. Well, then there's certain things I as a lawyer have to look into. So first off, when you look at the agreement of purchase and sale, if I'm representing a seller who doesn't agree with these things and they don't want the property to be insured, my contract has to be revised because it does require, the standard pre-printed language in the AREA agreement does suggest that the seller has to maintain fire insurance until closing. Whereas if I don't have that insurance and now I've signed off on the contract that I will have it, that becomes a potential issue for me from a breach of contract perspective. Now, as a buyer, if I'm a cash buyer and if a cash buyer walks into my office and says, I'm going to give you a certified check, it's not money that's borrowed by a bank, there's no mortgage, and I don't want fire insurance, I don't believe in it, I'm going to let it be, well, that's up to you. You can instruct that. I will have you sign off on a whole bunch of documents indemnifying myself and my law practice from your decision. I will make sure that the decision is informed, but as long as you're not borrowing the money and it's not financed, I have no concern with that outside of me telling you what your potential pitfalls are in doing that. The only time fire insurance is required is when you're borrowing the money, and as a condition to the lending, the lender says that the only way you can disperse this money and apply it to the purchase is if you have a satisfactory insurance binder that guarantees us replacement cost or a certain amount that covers our mortgage in case there is a fire or anything to that effect.
Now, Ricky, you've been on both sides. You represented buyers and sellers. If you're able to leave us with a piece of advice for both, what would it be?
Make sure your contracts are crystal clear. There should be no uncertainty. Make sure you've done your due diligence on the realtor you're working with. There's a team that supports that realtor. And make sure that, you're not blindly signing documents. It's very trendy now to sign documents electronically. And, we're seeing a lot of different things happening. But ultimately, you have to appreciate that when you're buying a property, it isn't a bag of cookies. It's one of the biggest financial decisions you're going to make in your lifetime. And you have to give it the time and allocate the resources required to make sure that your decisions are informed. If you don't understand something, don't just take your realtor's word for it. Investigate further, look into it, and satisfy yourself, because although we're licensed, we're insured, there's some, responsibility on our part to look into these matters. You, as a buyer or as a seller, your best remedy is to make sure that everything is structured so that you know exactly what you're getting into right from the start.
Ricky, if buyers or sellers want more information on this topic, how do they get a hold of you?
You can call me anytime direct at 416-731-8478. Again, 416-731-8478.
Ricky, thanks for the information. We're so glad that your participation with this show will survive and not merge on completion.
Looking forward to it, guys. Thank you so much for having me.
That's our show for this week. Remember, if you need to connect with Asif Khan or if you missed any part of On the Market, go to our website, 1059theregion.com. Thanks for listening.
Need to connect with Asif Khan from RE/MAX Prime Properties? Call him, 416-985-KHAN. That's 416-985-5426. Or email asif@thehomeshop.ca.